From its beginning, CMC has welcomed everyone. I'm Kelly Atkinson, the Director of Business Systems at Barnes & Thornburg and also Chair of the CMC Board of Trustees. We're so pleased that you're here today. And before we begin, a few other important thank yous. Thank you to the Center for Human Kindness at the Columbus Foundation and the Columbus Dispatch, because they help present today's live stream. So let's thank all of those supporting today's forum. Today's panelists will unpack recent events in attention-getting criminal cases, both in Ohio and nationally, and explain how criminal investigations really work. How do FBI agents obtain search warrants? Does lawyering up make you look guilty? How do potential defendants learn that they are under investigation? We will explore these questions and more with today's conversation that comes right out of recent headlines. So please welcome today's distinguished speakers. Christopher Kim, former FBI special agent and a senior managing director with Guidepost. The Honorable Algenon Marbley, Chief Judge of the Southern District of Ohio. Ron O'Brien, former Franklin County prosecutor. And our host, David Axelrod, attorney at law with Shumaker, Loop, and Kendrick. You can learn more about all of these speakers in your forum flyer. And David, we look forward to today's conversation.
Thank you. Thank you. Well, we all seem to have acquired a new vocabulary in recent years, words like special prosecutors and predicating investigations, congressional subpoenas, contempt of court, classified the Espionage Act, all sorts of things. And of course, we read about them in the newspaper, but the newspaper and the media just sort of skip the tops of the waves, when in fact there's a lot going on beneath the surface of the ocean. So we thought it would be fun to get the four of us with diverse experience and overlapping experience, and we're all friends, so we hope we set a good example of civil discourse, but we thought it would be fun to take a deeper dive and to talk about some of the things that you don't always see and you don't always read about. Let's talk about how cases get started. Chris, would you tell us how that happens at the FBI?
Sure. So predication, I think it's a word that probably a lot of us have heard in the media. So the FBI has, in terms of their purposes, they have the ability to investigate federal crimes as well as any threat to national security. And those two purposes, if there is any allegations or information related to any of those, the FBI has an ability to open a case that's predicated on that. So it really is a very, very low threshold, and I think that if you actually look at some of the facts related to the current events, that threshold is likely to be met in the past in terms of the investigations regarding Trump. So,
do you respond to reports in the media?
Does the FBI?
Yes, the FBI. You know, there's a drumbeat.
So I was just telling somebody on the table that when I was an FBI agent, I never talked to the media because I feel like what good use. No offense to the media, but especially if you have an ongoing investigation, as an investigator, your job is to figure out what the facts are. And then we had media folks who that's their job to field any inquiries or questions. But in terms of the investigation, for us, the special agents involved, we just focused on the investigation and not what was reported in the media. So,
well, Ron, let's assume there was a public scandal of some sort, and there's just a drumbeat of press about it. The newspapers talk about it. They talk about it on television. There's just all sorts of attention on it publicly. As the prosecutor, do you pay attention to that? Do you think about investigating just because you've read about it in the newspaper?
Well, I don't think just because you read about it, but I think somewhat in response to the question that Chris just answered, sometimes an investigation gets initiated by what you do read in the newspaper. I can think of several cases that I did work with the FBI on that the case was open because of a series of articles done in the Dayton Daily News that dealt with folks in the legislature. And that commenced the opening of the case. Certainly you don't talk with the journalists that may have caused the articles to be written in the first place, but sometimes a case can be opened that way. And certainly, if you're doing your job right as a prosecutor, and at least in state court as an elected county official, if you're doing your job right, you don't let those outside influences indicate where you're going or what you're going to do. Certainly, you can keep track of what's being reported. And Carol Lupert, for many years, called me almost daily, asking what was going on. Usually, she was following up something that happened the night before, because I think, unlike the FBI, we get most of our cases from either the sheriff's office or the police department, where they already have a suspect under arrest, in custody, and they're bringing it to us for purposes of review and presentation to the grand jury.
You know, you just touched on something interesting. You referred to working with the FBI. Now, you're a county prosecutor. I think people would find it interesting to understand how the locals and the federal law enforcement agencies work together.
Well, at least in this county, and I can speak probably back for the last 40 to 50 years, there's been a very good relationship with the Franklin County Prosecutor's Office and the United States Attorney's Office here in the Southern District of Ohio, and in particular in the Columbus office, as well as the FBI. More so recently on the kind of cases we're talking about today, once they formed a public corruption unit.
So how do you decide whether a case winds up in federal court or state court?
Well, and sometimes it's a result of a negotiation. I was just telling Judge Marbley about having the opportunity as a special assistant U.S. attorney of appearing before a federal grand jury. I've only done it once during the time I've been involved in the criminal justice system, but the state and the federal are different. And in the one particular case that I did appear before the federal grand jury as a special assistant U.S. attorney was a federal civil rights violation involving police misconduct, where we wanted to present the case in state court, and Ben Glassman, who was the United States attorney at the time, wanted to present it in federal court, and we negotiated amongst ourselves and did prosecute it in federal court. But as a special assistant United States attorney, I was assigned to the case with the now U.S. attorney, Kim Parker, who was the first assistant at the time. So I've had the experience of presenting a case in the federal system. Most of the time, it's the nature of the facts and circumstances. We obviously handle bank robberies as aggravated robberies, and as a younger prosecutor, there were very few bank robberies we handled in state court, because they were pretty much principally handled in federal court, where nowadays, unless it goes across county lines or across the Southern District or multiple districts, we will frequently handle a bank robbery in state court. And I would end by saying at least one case that similar to the one I just mentioned that I did prosecute in federal court because there was concurrent jurisdiction. We had a bank robbery in the east end of Columbus where a special duty police officer was shot and killed. And I wanted that to be prosecuted in state court, and there were multiple reasons where we finally concluded with the police department, the FBI, our office, and the U.S. attorney to prosecute it in federal court in front of Judge Frost a few years back. And so sometimes it's a negotiation process. Mostly it's just involving on what the nature of the crime is and what the evidence is.
You know, now, in connection with the search warrant executed on President Trump's home in Florida, there was discussion with the special master of allowing the FBI agents and the Department of Justice to look at the documents that related to a counterintelligence investigation, excuse me, as opposed to the documents involved in the criminal investigation. Chris, you talked about this a little last night. Tell us the difference and whether they overlap and whether what was being discussed was in fact practical.
Sure. So I think sometimes it's probably a good reminder. So the FBI has a criminal mission in terms of investigating crimes, but they also have a counterintelligence mission, which basically is to thwart foreign governments to try to gain access or information in terms of U.S. information. So Mar-a-Lago, that case, if you look at it, you have a lot of classified documents there. Some of them are top secret, and some of them are actually SCI, which is special compartmentalized information. So this is sort of the national security realm where, if you think about it, it's like, these are intelligence information that could be a threat to the U.S. in many ways. So in this case, you have an overlap, because I think it was initially opened in the counterintelligence sort of division, but because there's possible violations of federal criminal violations, I think that you probably have both sides in terms of both of these sides of the house of the FBI investigating and needing to review the documents. And just because you're an FBI agent, and this happened to me, you have top secret clearance, but you might not have SCI clearance, which means special clearances are depending on where the information is gathering. So you might not be, even if as an FBI agent, be able to review that document. You actually have to get clearance to get access to the document. Some of these documents that were found in Mar-A-Lago. So, depending on the document itself, you need FBI agents with that special sort of a clearance to review the documents. So, even with the special master, I mean, I'm not sure what kind of clearance he has, but he would need to get that kind of clearance as well to review those documents as well. So it's not as easy as you think it is. It's not as clear. So depending on the document, you really need that clearance, even if you're an FBI agent, to review that document.
There are all sorts of rules about where you can review those documents too, aren't there?
That's correct. So how many people know what a SCIF is? If you know what a SCIF is, you probably work for the government. So a SCIF is this super secret sort of area where you can review these SCI type of documents. By the way, I think Mar-A-Lago did not have one of these SCIFs there. So those are the areas that you can review these type of documents in this space, right? So even where the FBI offices are, they have little areas where there's a special SCIF where these documents can be stored and reviewed. So in this case, I think my understanding is that some of these documents are not only top secret, but also SCI. So these documents should be stored there, and then those who have access to enter that room, then will be able to review those documents as well. So it really is a process, and there's a lot of protocols involved because of the nature of where the information is coming from. So when you read in the news that these documents are there, why can't you just review it? It's not as easy as it is. It really is. Depending on the document, case-by-case basis, each document will have its different clearance and who can review it and where they can review it. So,
I might add, the occasions I entered a SCIF here at the FBI office here in Columbus, it was like a shakedown. I had to leave my cell phone outside, and even though I had proper clearance, no cell phones in the room, so as to avoid taking pictures and those kind of things. So it is very restricted.
All right, let's talk about a hypothetical. It's 7 a.m., and you're having breakfast, you're minding your own business, it's a work day, getting ready for work, and there's a knock at the door, and it's 2 FBI agents. Why does that happen? Chris, why do they show up at 7 a.m., and why do they show up in pairs, and why do they do all the things they do?
I actually want to listen to what the judge would have to say about that. I mean, I think, obviously, getting somebody off guard is probably one way to get somebody to talk to you. There's a bunch of cars here from Shumaker telling you why you shouldn't do that. But I think from the FBI's perspective, you want to get somebody sort of with their guard down, talking to you as a normal person. I mean, that's probably the best scenario for an FBI agent to get something in terms of what the truth is. So it's not just an FBI. I'm sure, other law enforcement also do the same tactic, right, in terms of trying to get somebody to talk to you before they wake up.
I might add, frequently I would have cases where the FBI did that, and they used the airport as a location. If they knew someone was getting off a plane, was going to be at the airport, they approach them at the airport, again, trying to catch them off guard.
One of the great...
It's certainly better than the no-knock warrants, and where where agents or police officers might go and mistake someone for someone else, or a cell phone for a gun, or a ham sandwich for a gun. So what former Agent Kim outlined is probably a preferred course, even though it's at 7 a.m.
One of the great frustrations excuse me, of being a defense lawyer is most of the time I don't get hired until after the subject has been interviewed by the FBI at 7 a.m. in their kitchen. Everybody knows the Miranda warnings. We've all seen them on TV. We've all heard them. Most of you can probably recite them, and nobody pays attention to them, which, of course, is why we've created that card.
I don't know if that's entirely true. Judges do.
Well, that's true. That's true. That's true. But,
And if I'm not mistaken, you filed more than your fair share of motions to suppress those statements that were given, in derogation of the Miranda warnings.
You know, I thought the fun part of this was going to be I was going to be in control. You know, when
You have a federal judge on the panel, you're never in control.
Judge, the truth is,
We're good friends, by the way, so.
and it wouldn't matter whether you were a federal judge or not, you would be in control. You know, when I first came to Columbus, I was a partner at a law firm with I had a late partner. He's no longer with us, but he told me a story about this that has always stuck with me, and I try to use it with clients to get them to pay attention. He had an investigation by an FBI agent that we knew and was a really good guy. His name was Steve Glazer. He was kind of a Columbo character, kind of a wrinkled raincoat. Judge, did you know Steve?
I don't believe so.
Well, this is a long time ago. This is before you were on the bench. But Jim talked to his client and he warned him. He said, he's going to show up sometime when your guard's down. He's really low key. He's just going to want a minute. It's no big deal. You know, relax. You don't need counsel present. Don't talk to him. So eventually the client called and said, you know, you were right. Last Saturday afternoon, I was watching the Buckeyes game. There was a knock at the door, and it was Agent Glazer. Jim said, you didn't talk to him, did you? He said, well, you know, it was rainy. I had to be polite to him, and, you know, I couldn't just turn him away at the door. And Jim said, you didn't let him in the house, did you? And he said, well, you know, just for a minute. I mean, we watched a few downs of football together. It really was nothing. We didn't talk about anything. So Jim called Steve and said, what happened? And Steve said, he confessed. So as a result of that, we created business cards where I still do this sometimes. I take my business card and I write on the back of it, this is my lawyer. He says that if I talk to you, he'll kill me. I tell him, hold the card up and read the back of the card.
I might add, David, a benefit the FBI has when they do those either surprise interviews or a formal interview. There's a federal statute that prohibits lying to law enforcement, and that is a very effective tool for federal agents. We don't have it at the state level. There's almost literally a pass to lie to the police when someone either's interviewed or arrested or interrogated. And as you've seen over the years, sometimes in these kind of cases, the strongest charge that the government has against the suspect is lying to the FBI agent.
Well, you know, as is Ron's want, he's touched on something pretty interesting that we've read a bit about in the media. You see people get prosecuted for the statute is 18 U.S.C. 1001. You see people get prosecuted for 1001 violations, and they complain, this is terrible. It's just a process violation. They didn't catch me doing anything bad. It's just the process. And they minimize the importance of that statute and of the prohibition against lying to law enforcement agencies. Judge, what's your perspective on that? Is a process crime less significant than the sort of substantive crime people are referring to?
No, I don't. It's like when people talk about the Fourth and Fifth Amendments, and it's no big deal. And in that context, whenever there's a Miranda violation, you know that the Supreme Court has somewhat diluted Miranda. So now if there was a good faith basis, as the court set forth in Leon, then, you know, the statement can still come in. Or if the property would be inevitably discovered, it would still come in. So many of the gains of the rights revolution during the era of the Warren Court have been significantly undermined. But I don't think that there is a difference. A constitutional right by any other name is still a constitutional right. And it is not inconsequential, it is not insignificant. And so by the same token, on the law enforcement side, if you violate the statute, you violate the statute. And there are consequences to violating the statute. So I think that's really a distinction without a difference. And I don't think that it should be treated any differently. And I think that most judges tend not to treat them differently. It's like sometimes defense counsel, and you know what I'm talking about, will argue that this is a victimless crime. It's a white-collar crime as opposed to a blue-collar crime. And as you know, in federal court, we don't have as many blue-collar crimes as you do in state court. We don't have the the assaults and some of those types of offenses that we try in federal court. But the impact on the citizenry is as significant as it is to that singular victim who was impacted by being held up at gunpoint. So I don't see the difference. The color of the collar makes no difference to the court.
So let's shift gears. In addition to agents knocking on your door at 7 a.m., there are grand jury investigations. The grand jury is interesting to me because it was first recognized in the 12th century, and King Henry II actually usurped power that had belonged to the church by requiring that all crimes be commenced by indictment by a grand jury, which is called a true bill. It wasn't until the 17th century, though, that it emerged as a shield for the accused. Until that, it had just been a tool for political repression and accusations. Defense lawyers like me think it's not the same thing now that it used to be. Ron and Judge, talk to us about what a grand jury is, how it works, and what really happens in the grand jury room. And I guess also, what's its function today? Is it really a protection for citizens, and will a grand jury really indict a ham sandwich?
Well, it has two, in the federal system, and I'll defer to Ron in the state court system, but in the federal system, grand jury has two functions: to investigate crimes and to make the initial determination as to whether a crime probably was committed, and this was the person who probably committed the crime. And oh, by the way, just to close the historical loop that Mr. Axelrod started, it was incorporated into the Magna Carta in 1215 and then into the Fifth Amendment. So that's how it came to be an integral part of our jurisprudence and of our laws and values. And I think that it's important. But I don't think that the grand jury would indict a ham sandwich, because the grand jury is typically comprised in the federal system of 16 to 23 individuals. And in order for an indictment to issue, a majority of those grand jurors have to determine that a crime probably was committed and that this person probably committed the offense. It's not the beyond a reasonable doubt standard that is the highest standard known to American law that you see in criminal cases. It is that whether this person probably committed it and the crime was probably committed and this person probably committed it. And so you can't underestimate the acuity of those who sit as grand jurors. I think that when people make that comment, that's a form of disrespect to the citizenry, because I always believe that jurors are the most fundamental part of the American justice system, because you have fellow citizens who get to sit in judgment of others, of their fellow citizens. And, you know, our system of justice is not perfect, but I think that it's probably the best in the world. And I think that because of the jury system, including the grand jury system, and they get it right. They generally get it right, even though you may not want to see the sausage being made. but they typically get it right. So if the ham sandwich was found to have committed a crime, and the ham sandwich probably was the entity that committed it, then the grand jury will issue what is called a true bill and then an indictment. And if not, it will not. But I believe, you know, in the system, and if the grand jury has made a mistake, the petit jury at the trial level will, I think, get it right. That's my take, Ron.
Let's talk a little more about the ham sandwich. I mean, actually, has anybody heard that expression before, that a grand jury will indict a ham sandwich? Do you know where it came from? Anybody? That was first uttered by Saul Wachtler, who was the chief judge of the New York Court of Appeals, which is the highest court in the state of New York. And he made that comment, and interestingly, later on was indicted by a grand jury and went to jail. True story. You can't make this stuff up. But let's talk about why people think a grand jury might indict a ham sandwich. Ron, tell us about the rules. I mean, who runs the grand jury? Who tells them what the law is? Who rules on objections? Are there rules of evidence? All those things.
I think the comment probably does relate to the way the grand jury is set up, and the defense and the defendant don't have a role. It's the prosecutor typically who has been assigned to the grand jury unit. We had maybe 5, 6, 7 people regularly presented cases to our grand jury. It was in session 5 days a week during the pandemic because people can't be arrested without an indictment within 10 days if they remain in jail. So we ran the grand jury full-time all through the pandemic, and we're lucky enough to get jurors willing to come down there for it. But the Ohio Constitution requires all felony charges be pursued by an indictment, with few exceptions that, from a practicable standpoint, don't apply. So anyone who's going to be prosecuted for a felony, whether it's bad check or capital homicide, must have their case heard and prosecuted by way of indictment from the grand jury by the Ohio Constitution. And so we view the function kind of 2- or 3-fold. First, and for years, every 3 months, I explained to potential grand jurors as they were being oriented that they would see run-of-the-mill cases, even though they were felonies. They could be bad check, receiving stolen property, weapons offenses, robberies, burglaries, drug offenses, that an arrest has been made by the police. They go down to the sheriff's hotel to be slated. They make an appearance the next day, are given the opportunity for bond then, and then a clock started when that arrest was made. And if they're in jail, we have to either release them or secure an indictment or hold a preliminary hearing, which is fairly rare too, because that's a mini trial. And then secondly, if they were out of jail, you had to present the case within 15 days. So when that clock starts running, we get the police to prepare a summary, present it to us. We would then review it, present it to the grand jury on a schedule, hearing anywhere from 10 to 50 cases a day that grand jury can hear. Hearsay evidence. Hearsay evidence is not permitted during trial. There is no cross-examination. If there's questions on law that are in a jury trial addressed by the judge, typically they're handled by the prosecutor, explaining the difference between murder, manslaughter, and reckless homicide, being those perhaps 3 different degrees of homicide. If there was a question based on the facts the grand jurors heard, if they had a question, or we would usually in advance explain to them what we thought they should consider as potential charges.
Ron, excuse me for a minute, Dave, but would you tell the audience about we talked about a nuance that you introduced into your grand jury that I think is really beneficial that our audience needs to know about in the case of police, the allegations of police misconduct.
And at least that is somewhat in the second category of cases grand jury hears, are either investigations or special cases. I always use the example of having, actually this was another police officer that got shot in the line of duty, where the gun, the offender was a felon who didn't have the right to have the gun in the first place. The gun had been purchased at Vance's gun store up there on Cleveland Avenue, and when they went and got the form from the ATF, they found the lady that he was living with had bought the gun. So we thought that was important to find out, his access to the gun. So when the police knocked on the door, guess what? She didn't answer the door, and when they finally talked to her, she wasn't talking. So we slapped the grand jury subpoena on her and forced her to come down and testify. That is another investigation, if you want to call it that. But we adopted a policy, and actually it was not my policy. Mike Miller, my predecessor, in 1980, adopted a policy, which I continued on for the 24 years I was prosecutor, that in all police shooting cases, because of the perception that police investigated, prosecutors who work with police daily, are the ones that analyze the facts and or present it to the grand jury, that in all police shooting cases, we would present it to the grand jury. Going back to the standard of probable cause, we would present cases where we did not think there was probable cause to believe a crime had been been committed, i.e. a murder by an on-duty police officer, but we would nevertheless present that to the grand jury so that the public could feel that group of, at least in our court, 9 grand jurors, 7 affirmative votes to return an indictment, and you have up to 4 alternate jurors that can get mixed in, that there could be the feeling that those folks are the ones hearing and deciding whether or not an indictment should be returned, not Mike Miller or Ron O'Brien analyzing the case in advance. And I think for many years, up until probably I would say the last 5 years, that was an acceptable, I think, public perception issue. And as a result of police misconduct, probably going back, starting in Ferguson, Missouri, and then continuing up to the George Floyd case, the public had additional questions. So in my last few years I was there, I actually didn't handle cases involving police shootings, got another prosecutor to handle it, either at the Attorney General's office or we swapped cases. I handled some cases for the prosecutor in Dayton and for Cleveland, and they handled some cases as a special prosecutor for me, again, Judge, to avoid the public perception that we were either covering up for police officers that did something wrong because we worked with them daily, or sometimes people would even claim that the FOP had an undue influence over the handling of those cases. So I mentioned instructions on the grand jury. I also adopted a policy of having the administrative judge. I don't think we did it when Dan Hogan, who's in the audience there, was the administrative judge in our court. But I adopted a policy of having the judge give the grand jurors the law. And that way we were not subject to criticism that we had not properly instructed the grand jury on the deadly use of force rules of law from the High Supreme Court to the U.S. Supreme Court. So at least I think in that arena, it helped address the perception issue to the extent there was one. And that, you know, I viewed in the investigative kind of role of the grand jury.
You know, the rules are as relaxed as they are in the grand jury because it's an inquisition, not a trial. It's not an adversarial proceeding, and so it's really an offense without a defense. But it's easy when you listen to the things Ron says, all of which I agree with, but it's easy to miss the significance of some of them. For instance, the admissibility of hearsay before the grand jury. That means that Agent Kim can say that Mr. O'Brien can say that Judge Marbley can say that, or that Judge Marbley said that David Axelrod said, and that can come to the grand jury, and it is at least technically not improper. So it's a very different thing from a trial. It's really kind of hard to imagine, partly because it's done in secret. Judge, tell us about grand jury secrecy and why it's so hard, even after the trial is over, to find out what happened in the grand jury.
Well, it's necessary because you are actually protecting the public, and you're protecting both the subject of the grand jury and any potential targets, because it's certainly conceivable that the grand jury will not return an indictment. And if the grand jury proceedings were public, then, you know, if you, David, were the subject, and I know that you're a man of prelapsarian integrity, so you would be the subject of a grand jury investigation, but just hypothetically, if you were, then, and the grand jury declined to indict, returned a no true bill, then your reputation would be ruined in the community because of the suspicion. And I think that at its outset, at its inception, that's why they found it necessary to maintain secrecy in the event that the grand jury did not return a true bill. And so I think that it's really important. Also, because some, you know, federal grand juries investigate really complex schemes, you know, particularly fraud, Ponzi schemes, and the like. We talked about National Century, for instance. If it's public, then it's hard to ferret out the crime because it's like whack-a-mole. You find out something here, then the other part disappears. And so I think that there are only good things that happen from the secrecy of the process. If the person is indicted, then she or he has an opportunity to go to trial and to be heard and to present a defense, though she doesn't have to, because the government still has to prove that person's guilt by competent evidence beyond a reasonable doubt. The hearsay that came in before the grand jury will not come in unless it satisfies an exception to the hearsay rule. And so it has worked. It may need to be tweaked, but the secrecy component, I think, Ron, has worked extremely well. I mean, there have been some high-profile prosecutions of people who were very well connected who, if the secrecy component did not work as effectively, they certainly would have known that they were being investigated, and that's typically not the case. I will add, too, David, that for the federal grand jury, in order for a true bill or an indictment to be returned, there must be a vote of 12. I think I said a majority was a majority plus one.
All right,
Quickly, David, in my younger days, witnesses were not killed. Another good reason for grand jury secrecy is with Mexican cartels, with gangs, and drug dealers that have, territorial dispute or whatever. Witnesses are killed, and if it's not secret and the information becomes known and available, that can cause witnesses harm, threats, and actual being killed. On the protection of the defendant, the example I like to give is if someone is investigated for child sexual abuse, and the case ends up getting presented to the grand jury, if that's a public information and not secret, that could ruin a person's reputation for life. And at least they would be better off if they were indicted, where they had the opportunity to have a trial and have their name cleared by an acquittal if the rule of secrecy didn't apply. So I think it's not often viewed as a protection for the suspect or defendant, but I think it is equally on the same plane as protecting those witnesses that might otherwise be killed.
And I will add to what Ron has said, it's not just for the protection of witnesses, but oftentimes prosecutors, especially in some of the high-end drug cartel cases, have put their lives at risk. And certainly you have a number of undercover agents who tend to testify before the grand jury, and their identities can be disclosed. So,
I think if I could just add that in terms of the integrity of the investigation, it also protects as well, right? So I think the judge mentioned the complexity of some investigations. As an investigator, you want to investigate without too many influences and biases or other people knowing about it. So I think secrecy of the grand jury investigation allows investigation to go on with as least influences as possible from the outside or individuals that are trying to affect it as well.
we could, and as a defense lawyer, we could, but will not, debate for a long time the merits of the grand jury secrecy rules, but suffice it to say that I agree with a lot of what was said, but I have a very different perspective on it as a defense lawyer. I am told that we are out of time and ready for questions, so.
Hi, I'm Lainey Cuthbert, and I'm going to be curating the questions online. Those of you in the room who have questions, please feel free to get up, because we'll do every other one. So we want to give everybody an opportunity. I want to thank all of you for being here. This has been a great discussion. Nadia Bashir asks, people always draw the obvious comparisons between Watergate, Whitewater, more recent events. In what ways do you think these scandals are vastly different?
Ron, you want to take it?
Well, I would say they're similar by virtue of political overtones, and I think they're different, obviously, in terms of times. I have observed, for what it is worth, that more often nowadays we've tried to criminalize the political process and turn things that maybe in past years were not deemed or viewed or investigated or prosecuted as crimes. More so nowadays, you will have a demand or a claim or an investigation being go forward because of the political overtones associated with it. It's in some instances you could even compare it to a gotcha game, where I remember again going back a few years that when the Attorney General Robert Kennedy, under President John F. Kennedy, chased Jimmy Hoffa from one end of the country to the other. Jimmy Hoffa was quoted as saying, if someone chases you long enough and puts you under the microscope long enough, you're going to find they did something wrong. And so I think we have moved from that time to now where that happens more often.
I agree with everything that you just said.
Make a note of that, please.
I will note, however,
Sustained.
that one thing that I think is important is that those investigations demonstrate that no one is above the law. And that's probably the most important takeaway for me. In a democracy, no one can exist above the law. In an autocracy, the autocrats determine who will and who will not be prosecuted. And so as a federal judge, it is important that all prosecutions are brought and light is shed on them so that we can see whether our public officials are doing the jobs that they're supposed to do and whether they're acting in accordance with the law. One of the instructions that I give to all of my juries, and it's my favorite one, is that the law is no respecter of persons. And I think that that's one of the key values of our criminal justice system. So I think that the importance of it is that it shows that no one exists above the law.
And at least I certainly didn't mean to suggest in any way otherwise. I guess in trying to answer the question about how things are different now than they were in the past, I think we get this more often now than we did back in Watergate days.
Next question.
The issue that I'm interested in is the issue of delay, and you didn't speak about delay. A speedy trial, if I remember correctly, is guaranteed under the law. However, it appears some people use delay to their advantage. And I'm thinking of the Larry Householder case, which I think is finally going to be tried in January. And you read all the time that former President Trump's attorneys are using tactics to delay the final outcome. Talk about delay.
I want to address that because Carol is one of my favorite reporters. She always called it fair and square, and she understood the value of the Fourth Estate. And she was during the glorious days of the press when it didn't exist for entertainment purposes. Now, having said that, we have a Speedy Trial Act on the federal side. In 25 years on the court, I don't know that we've ever gone to trial within the 70-day stricture of the Speedy Trial Act. It's almost impossible. I think the act was enacted for the public to allay all of your concerns about delay. But oftentimes in complex cases, it takes longer to prepare than 2 months. And, you have sophisticated lawyers, former prosecutors like David Axelrod, who are defense counsel, who will leave no stone unturned because you cannot afford to. We're not dealing with money in a criminal case. We're dealing with the most important thing that we have, our liberty. There's nothing that compares to freedom. And so you could be deprived of your liberty and your integrity and your good name for a very long time if you are forced to trial when counsel is not ready. And understand this, the government has had unlimited time to investigate the crime and to bring it before the grand jury. And then you get 70 days. And so judges, that's where judges come in, Carol, and you know, we can usually determine when someone is gaming the system and when someone has legitimate concerns. So what I do is at arraignment, since I know that the case is not going to go to trial within the time frame of the Speedy Trial Act, I'll say, look, when you get together for the discovery conference, give me 3 dates that represent sufficient time, in your view, to be prepared to go to trial. And then when you ask for a continuance, if it's well pleaded, then I'll give it to you, and I'm going to give you one of those dates. And that date is not going to change, barring an act vis major, an act of God. And that seems to work reasonably well, because the good lawyers can tell you, look, it's going to take 6 months. It's going to take 9 months to get ready for this case. And so I really did, thank you for asking that question, Carol, but I really did want to address it so that people will know that we're protecting liberty interests and we're protecting society. So let's take our time, be reasonable, but not in such a hurry that we will make a mess of justice.
I'd like to
At least I would follow up that, Judge, by saying, if the defendant demands in state court a speedy trial, they're going to get one.
Okay.
If they're in jail, we have to be ready to bring a jury up and try the case in 90 days. There are some extensions. For example, if they do ask for discovery, the amount of time can get told. But generally, if someone wants a speedy trial and demands it and refuses to waive it, they can stand in front of the judge and say, I'm not waiving it, and the judge is going to have to say, bring up the jury. So we have less of those kind of issues. Usually, as we have long heard, you know, justice delayed is justice denied, and at least I think delays hurt the prosecution more than they help the defense or hurt the defense. And so we always were prepared for a speedy trial. There are reasons the defense may want to delay it, but if the defendant himself or herself wants a speedy trial, they'll get it typically, and I assume that's true in your court.
In federal court, if someone, if a defendant asks for it, she'll or he will get it. But that doesn't happen either.
You know, one more practical view of this, just a personal example. I'm involved in a price-fixing case in Florida, and the government has produced 2.85 terabytes of data in discovery. 2.85 terabytes of data is more than 3.2 million documents, not pages, documents. So we as defense lawyers have to figure out how to manage that and figure out how to find the exculpatory evidence buried among all of the other stuff, and it just takes a lot of time.
Well, at least there's a jury down in Pike County that's deliberating right now, and I was involved in that a certain extent. In the discovery in that case, they talked about in gigabytes, and so and that was a lengthy investigation. So there are good reasons that both sides need to have to go through the evidence.
Householder case, we know of at least one wiretap, and there probably were more, and there probably were hundreds, if not thousands, of hours of conversation recorded, and the defense lawyers have to be sure that somebody listens to that and finds whatever exculpatory evidence there is on that, and finds whether there's stuff that counters the government's interpretation of it, and again, it's enormously time-consuming.
All right. I know this might be difficult, but we're going to try 2 more. We've had some very good discussion here. So I'm going to ask one more question, and we have another person in line. Alvin Bell asks, due process was considered so crucial to the U.S. constitutional writers that they mentioned it twice in the 5th and the 14th Amendment. Yet in Ohio, due process primarily benefits the rich and powerful. What will it take to restore due process to regular Ohio citizens?
It's a Judge Marbley question.
Well, I would add the Ohio Constitution.
I was feeling
has it,
vindicated
too.
because they were talking about Ohio.
And I would say Ohio has a similar due process provision in our Ohio Constitution that would apply, and I'm not sure exactly in what context the question is opposed, I guess, on the general theory that rich people get off and poor people don't. And at least I have not observed that over the years that is the case. Obviously, someone that has means is able to hire a good lawyer such as Dave Axelrod, who spends all those hours listening to it. But I would tell you this, the Franklin County Public Defender's Office here in this county at least has the best lawyers who are in front of those same judges every day, deal with the same prosecutors, know the detectives, and know what works. They know the sentencing habits of the judge. And so I have always observed that the Franklin County Public Defender's Office has the best lawyers to handle those felony cases in our court. They don't really get involved in a lot of the white-collar crime kind of things because someone does have the means to hire a lawyer. But for what might be those regular cases I mentioned earlier, I don't think anyone other than them would be any better.
I agree, although it's unfortunate that the perception identified by the questioner persists, and it has to do with values and issues broader than the administration of justice, either in the state or federal court, but it tells us where it's a good dashboard about where we are as a society and, you know, how we perceive our relative positions in society. Certainly, you know, when the Constitution was adopted, it made distinctions between along gender lines, along economic lines, because if you were not a landowner, you didn't have certain rights, and certainly along racial lines. But the Constitution, contrary to some of the protestations of originalists, the Constitution has evolved. And, you know, when you look at the Reconstruction Amendments, the 14th, 15th, and 16th Amendments, you see that what we really have is a Constitution that is a blueprint for a multiracial, multi-ethnic, multicultural society. And so, you know, it when applied in the context of a living Constitution, it works.
So we have time for one more question, and we are being asked to respond briefly.
I'm Kurt Looper. I keep hearing about investigations. I thought I knew the subject matter somewhat, but now I'm confused. There's investigations conducted by something called the FBI, investigations conducted by county prosecutors, and at one time I've heard about the Ohio Bureau of Investigations. So please tell me two things. What determines which of these government organizations conducts an investigation? And secondly, do private citizens refer cases for investigation?
Chris?
So again, with the FBI, we're talking about an agency that handles investigation of federal crimes or national security, right? So in the case of the Trump investigation, you had a foreign government, the Russian government. There was information that they were seeking to try to probably recruit individuals related to the Russian, Trump's campaign. So that's a national security threat which the FBI has jurisdiction over. I don't see any overlap with the state in that matter. But you know, I've worked on task force with the state where on drug cases, right? So there's a drug case in a county like Franklin County where we had investigators from the county or from the detective's office from a particular police department where the drug cases were involve individuals that might be prosecuted under the state or the federal. So it depends on the violation. If it's a violation that's jointly investigated by the state or the county, then it can be investigated together. But if it's a counterintelligence, meaning like a foreign government is trying to infiltrate a U.S. interest, that is primarily the jurisdiction of the FBI.
Well, and of course,
at
we
least
see
on the question as to private citizens, when a private citizen picks up a phone, calls 911, and a police officer comes out and takes a report, whether it's a burglary report, an assault, a theft, that commences the process whereby an investigation or prosecution may happen. And so private citizens can do that. And I might add, I've always felt a bit contrary to its terms, but in Ohio statute, it says a citizen can go to the clerk of courts, file under oath a complaint under an Ohio statute, and you can have a hearing in front of a judge without the police being involved, without the prosecutor being involved, and the judge then makes that initial determination if there's probable cause, and then that case, at least on a misdemeanor level, would and could be prosecuted simply because of the complaint filed by the citizen. Obviously, if it's a felony, it would have to then go to the county prosecutor because of the Ohio Constitution and require presentation to the grand jury. But if the facts are there, the facts are there, and it likely would be prosecuted.
And by the way, just a private citizen also can make a complaint to the FBI too. So, I mean, if you have allegations that a federal crime has been made, you can go to the local office in any FBI office, maybe you can do virtual these days, but you can go to the FBI and say, I have information that so-and-so might have been involved with, not that anybody be involved, but, you know, a public official was involved with possibly receiving, you know, a bribe. And you can contact an FBI office and make that allegation or complaint, depending on where you are.
We are out of time. Thank you all very much for your attention.
Okay, I hope you all enjoyed today's forum, and as you can tell, there are still lots more questions. So I hope that you will continue your own investigation and actually learn a lot more about what there is out there. So thank you to our online virtual seat patrons and to the Center for Human Kindness at the Columbus Foundation and the Columbus Dispatch for today's live stream. Please make plans now to attend our next forum, the New Columbus Downtown Strategic Plan, on December 7th. And our very special appreciation to today's speakers, Christopher Kim, Judge Marbley, Ron O'Brien, and our host, David Axelrod. Thank you all for joining us, and we look forward to seeing you next week as the Columbus Metropolitan Club presents another community conversation. Thanks, everyone. Enjoy the sunshine.
Now, you should know, Dave